Thank you for joining us this afternoon. My name is Caroline Garstang. The objective of this webinar and of the associated GDPR guide is to provide you all with a checklist for GDPR compliance. As both a processor and controller of data ourselves, we've been faced with exactly the same challenges as you, so we know exactly where you are. Throughout the webinar, we will talk you through some of the challenges we've faced and the solutions to these. My colleague Sasha Schneider from our legal team and David Smyton, who joined NGA Human Resources specifically to head up our GDPR working group, will talk you through some of the principles and expectations of the Act as well, and what your supervisory authorities expect from you when we get to May the 25th, whether you're fully compliant or not. Throughout the webinar, we will run a number of polls, just asking some or canvassing for some up-to-date status stats around compliance and what your organisations are doing. During the registration process, we actually, just before I do this, I'm just going to put a legal disclaimer out there, because as I've already said, we are not a GDPR consultancy. We are, like yourselves, we're a processor and a controller of data, so we're here with you. We're in this together with you. But as I said, during the registration process, we asked the question, how confident do you feel that your organisation is GDPR compliant? And interestingly enough, possibly worrying, who knows, 41% of you came back to say that you were unaware of any GDPR projects in your organisation. This is not to say they're not happening, but throughout this presentation, David and Sasha will talk you through the need to have good communications throughout your compliance process, and also the need for your organisation to have a general compliance culture. At this point, we're just going to ask you one quick question. You can respond in your boxes. When do you expect your organisation to be GDPR compliant? Just give a minute or so for this. The poll is open. Okay, the poll will stay open just for a few more minutes. Has everyone had their chance to click? So a few highlights from the guide, which you're welcome to download after, or we will send you a copy of, are as follows. First of all, we have a comment from Elizabeth Denham, who's the UK Information Commissioner. Each country will have their own supervisory authority. Elizabeth says it's about having the right mindset towards data protection. And Alan McDonough, who heads up our HR working group, again, also said it's about having a team effort and a culture. And this again is backed up by Sasha. It's really about bringing a harmonisation of the requirements and the expectations of data laws we already have. And just my final note here is that the GDPR is actually a good thing. It's here to protect us all and put us back in control of our own data. These are the two spokespeople you'll have today: David Smyton, who is our GDPR and Security Programme Manager, and Sasha Schneider, who is our Privacy Counsel. And at this point, I hand over to Sasha.
Well, thank you very much, Caroline. Thank you everyone for joining. As Caroline said, 41%, that's a somewhat interesting figure, taking into consideration that May 25th is right on the corner. But as she also said, it doesn't necessarily mean that this doesn't happen in your company. And I mean, not repeating myself, but as you also said, David and I were working in our working group around GDPR, and we were well aware about how important it is to communicate the efforts that your company is probably doing in regards to GDPR. As Caroline started today saying, it's not really a consulting webinar. It's more of a best practice. Been here. This is our experience. This is where we thought, okay, this is more interesting from the questions that we have received from clients and internally also. So what we're focusing today from my end is really employee rights, the individual rights, and how they might impact you on a day-to-day basis, and additional major aspects from the GDPR themselves. As you can see on the screen there, you can see 8 individual data subject rights. Now, some of them are currently already active. Some of them, they are enforceable. They are not new to data protection law, and others, they are slightly new. And on these which are slightly new, I will extend a little bit more. I will just go quickly through them and explain some of them. But as I said, for some others, I will spend a little bit more time, and I think you will already know which ones I'm going to extend a little bit more. So if we go from top left, the right to be informed, very simple. It's a right that everyone has. And every individual can exercise all of these rights whenever they want. And it depends on which end of the questions you are. They might be an administrative burden or an essential right? But always think about, you're an individual, you're a data subject, everyone on this call. So every one of you has these rights that I'm going to speak about right now. And the most important one is the right to be informed. The right to be informed is the right that when you provide personal data, when you collect personal data, you have to inform the individual about who you are, which is the identity of the data controller, why you're collecting it, the contact details of your data protection officer, if you have one, if you're obliged to appoint one, which must be public, on what grounds you're processing the data. Is it legitimate interest? Is it consent? Is it because you have to comply with the law, etc., etc. All this information must be provided upon the moment when you collect that data. If you collect the data from a third party, you have to provide that information upon first contact with the individual. So think about you buy up a new company, you get a new set of databases. Well, then you must provide to these new individuals in your company, you must provide the information. Okay, this is what we're going to do with your data. That is the right to be informed. Now, if we go to the right to restrict processing, that is basically a right of a data subject, an individual, to block the processing, to contest the accuracy or require verification that effectively the data controller can process the personal data. It doesn't mean it has to be deleted. It doesn't mean that the data processor cannot process the data, but it is a request of the individual to you saying, okay, I'm not 100% certain that you effectively can process my data, so I request you that you restrict the processing. It's important to highlight that if this right is exercised against you, you have to make sure that this right is flown down to your third parties. So you get we are a third party, NJ is your third party. You receive this right to restrict processing from an employee. You have to flow that information down to us. So we restrict processing upon this right. Right to rectification. Fairly simple. It is to rectify or correct inaccurate data, or to complete data that is not 100% complete. There's nothing more to it. It's very simple. Right to access can be exercised or is somewhat similar to the right to be informed. So the right of access is actually getting all the information an entity has on me. Important to highlight is that not every set of data that you are requested to provide is necessarily something that you have to provide as is. In these types of subject access rights, it's important to highlight that one right doesn't out level the other. So if I request information about myself and it is in a set of data that is mixed up with another colleague, not necessarily you have to disclose that set of data. So you have to protect the right of the individual who's requesting access, but obviously you have to protect the right of the other individual's privacy as well. So you always have to counterbalance. And it's important to highlight that these subject rights, they're not unlimited. You always have the possibility to request more information, what it is that the individual is actually wanting to see. Very important, because many times you get a subject access request, an SAR, and you say, damn, I have 30 days, I have to comply with them, and here's every information you have. Take your time, it's 30 days, see what the individual actually wants. And then you can really see, okay, this is information, I can give that to you in 2 days. Otherwise, people start getting nervous, and then information may be disclosed that is not actually something to be disclosed. In regards to right to object, which sounds somewhat similar to the restrict processing, and it is somewhat similar to actually the exercise and the end, but the right to object actually is when a data controller is processing data in the public interest, or is processing for the purpose of a legitimate interest, then this right exercises. So, for example, take into consideration marketing. So I am a marketing company. I process personal data. I find out. I object. There's nothing that company can say to me. I object that you process this information to me. And this is when this right is going to be exercised. Now, these rights, they do already exist. So informed, restrict processing, rectification, access, and object. These are rights that you can find in every data protection legislation based on the EU directive, and in most of other global data protection laws and regulations, there you can find similar laws that provide these rights to employees and to data subjects. What is new is the right to data portability, automated decision-making, profiling, and erasure, or the infamous right to be forgotten, which I'm going to cover now. The right to data portability is actually what it says. It is giving the data to the individual so that they can take their set of data and bring it somewhere else. Now, this doesn't mean that the individual can exercise this right anytime without restriction. It is important to highlight that if an individual wants to exercise this right, the right to data portability, the legal processing needs to be consent. So if you process for legitimate interest, for legal provisions, etc., or any other kind which is not consent, then this does not apply. Only if it's based upon consent and the processing is carried out by automated means, so it has to be fully automated, then there exists that right to portability. If it's legitimate interest, if it's legal provision, if it's well, something that in the health industry, right, to protect the life and the security of the individual, then this right does not exercise. Very important to highlight. If you provide it, if that right exercises, then you have to provide the data in a structured, commonly used, and machine-readable format. That's basically a phrase from the GDPR saying, give it in a USB pen. Most likely it's that. That brings me to the next right, which is the rights in relation to automated decision-making and profiling. Now, as it says, automated decision-making, it has to be fully automated. So, for example, our business, NGHR's business, we provide HR Payroll services. We provide semi-automated services. Yes, we calculate HR, your payroll. Yes, we enter data into systems, but there's always a human intervention. Take, for example, a bank. A bank, you apply for a mortgage. the bank takes your data, puts it in the system, and then 5 minutes later it gets back a figure saying, yes, you can apply for mortgage or you cannot apply for mortgage. That's because the system takes an algorithm based on the data that you've provided, based on the own data that the bank has, and then yes or no. Which is also very important to say that this decision produces legal fact. That means you cannot get a mortgage from that bank. If there is fully automated decision making, but there's no legal effect, then this right to restrict automated decision making would not apply as neither. So it's always something that is combined, because the GDPR doesn't say that these rights are limited. They have to be taken, well, into comparing to the rights of the controller, taking to the rights of the data subject, putting them into context, and really protect sufficiently the data controller processing the data and the service and the individual, so that the right of the individual is protected, but not in detriment of the company itself. And last but definitely not least is the right to erasure or the right to be forgotten. Now, I personally have received many questions about the right to erasure, but I've always received it in relation to what is the right to be forgotten. The right to be forgotten is not a new invention. It is still the right to erasure. The right to be forgotten comes from a court ruling against Google in Spain. An individual actually wanted to get a mortgage from a bank. The bank found out that he had unpaid loans, but they found it out on the internet. So that loan had been paid, but even though he didn't get the mortgage. So what did that individual do? He went to court. He went even to European court and then won, because Google should have deleted that information because it's no longer relevant, because that didn't no longer exist. That is the right to be forgotten. If something is no longer relevant, then you can exercise the right to be forgotten, but that's more in data repositories like Google, Facebook, all of that. There's when you can exercise the right to be forgotten. The right to erasure is merely the right to request that the data is deleted to the data controller. Now, in our environment, in our employee environment, that doesn't mean that if an employee comes to you and says, I want you to delete my data, that you have to delete the data, because it wouldn't make sense. How would you get paid? How would you file Social Security? Wouldn't be possible. There comes again the legitimate interest and the legal obligations to process data. I cannot just delete your data, John Doe, because then you wouldn't get paid. I can get filed Social Security, whatever. So finishing this slide, take into considerations every one of you has these rights. You can exercise them and you can request them, or you have to comply with them. But these are not unlimited, except the right to object for direct marketing. That's the only one that's unlimited, but any other right that you can see here needs always to be put into context and to really thoroughly analyzed. My recommendation is, if you received a subject access request exercising one of these rights, and it's important to note that it's not necessarily that the data subject, it has to be in writing, but it's not necessary that the data subject comes to you saying, I, John Doe, want to exercise my right to restrict processing based on article blah, blah, blah of the GDPR. That's not necessarily. If the individual comes to you and wants to exercise one of these rights and just puts in writing, I object to you from processing my data, that's sufficient, and you have to exercise it. But you always have my recommendation, request more information from the individual. Always go back and say, what is it that you actually want? You could comply faster, or the individual actually doesn't really know what they want to exercise. Take into consideration that these are now free of charge, and you have to comply with them within 30 days. So maybe you get more requests of these if you have not dealt with them before, because as of today, in most countries in the EU, they are not free of charge, and in some countries they take a little longer to comply with, which is the UK, for example, which is 40 days. Next slide, please. Thank you. So Again, recapping on the 41%. That's not something that should alarm you. If you go back to your CEO and he doesn't know what GDPR is, then maybe it should alarm you. But it's very important to highlight GDPR is a team effort. Here at NGA, we have a GDPR working group. We have a dedicated program manager, and David will explain a little bit more when he presents now. But it's really a team effort. We have people from all over the company working on our GDPR program, because basically all of this, what you see there, all the obligations that we have to comply with, is not something that a one-man show can do while he has 5 minutes at the end of the day. That's not something that you can do within 2 months. I mean, if you're still sitting there and saying, what does GDPR stand for? Is it general privacy regulation, or is it general data protection, whatever? Maybe it's going to be a little less time for you. However, main points to take away from GDPR on this slide. Important, not in the EU. What does that mean? Not in the EU means that GDPR is the first law in this context that really applies outside of its location. That means GDPR is applicable in the European Union, in the European Economic Area, and outside of the EU or the EEA, anytime a data controller or data processor does process European data. So if you have operations in the US and you process European data, you have to comply with the GDPR. If you're in Colombia and process European data, you have to comply with the GDPR. It's that simple. If you don't comply with that, then you can get a major fine. Information law for processing, as I said before, data subject rights, very, very essential for the GDPR. Again, if you don't comply with them, major fines can occur. You have to inform the individual what you're doing with the data. You have to have a reason why you process the data. There's no longer the possibility to just collect data and nothing will happen. That's no longer possible. And cases like the Facebook case, the famous Facebook case that we just learned about, it was just that processing data, and no one was really aware about that. If you're on Facebook, which probably many of us are, well, we weren't informed that this Cambridge Analytics, or what it was called, was really analyzing our data. Individual rights and consent, you have to inform the individuals about their rights. You don't receive data subject access requests and saying, well, that's good. Well, maybe it's because your employees don't know that they have these rights. This is something that you have to inform every individual, that they can actually protect their data and have right to exercise certain rights. Accountability and governance, something that was newly introduced in GDPR. Every entity that processes personal data has to comply with the accountability regime in the GDPR. What does that mean? Well, you have to have documentation around why you process data. You have to have documentation around where you process data. You have to have documentation around why you don't process data. You have to have documentation for everything. You have to have a strict governance. You have to have a data protection officer if you require one, information security management system. You have to have your data transfers right. All of that falls into the accountability and governance structure of the GDPR. Breach notification, big fines down in the top, down below. You CFO, you're probably very, very well of that, because it's 2% global turnover or 10 million euro fines, or 4% global turnover and 20 million euro fines, depending on what infringement we're talking about. Just to let you know, information on lawful processing and individual rights and consent fall into the 20 million euro fine category. So if you don't get that right, these could get the high fines. In regards to the big fines, breach notification, that is also something that can get fined. The GDPR included the mandatory obligation to notify the Data Protection Authority. That is something that the data controller has to do upon awareness of a security incident within 72 hours. There's additional documentation available from the Article 29 Working Party, which is a European data protection group. So check them out, read the guidance there, and get this right, because if you don't comply with them, then you can get into massive fines as well. International data transfers, as I said, that falls into the accountability and governance structure. You have to have your data transfer mechanisms right, which could be BCRs, binding corporate rules, which are now fully signed off by the data protection authorities in the EU. If you use EU model clauses, these are fine as well. If you use Privacy Shield, it just has been signed off by the EU Commission in the summer, last summer. All of that, you have to have documentation ready. And this is something that the data processor also has to comply with. Privacy by design and by default. If you implement a new system, if you implement a new process, all of that needs to have data privacy at its very beginning. And if you have already something ongoing, you have to have the capability to introduce data privacy into existing processes and systems. There's no longer possibility just to put into a systems that's work and then it collects data unlimitedly if it's not required. That is against the data privacy by design, by default concept of the GDPR. Data protection officer. Certain countries in the EU, and they already have the obligation to appoint a data protection officer. Most famous is Germany. Germany has the obligation long-standing, and Germany already confirmed that it is going to be a mandatory obligation still with the new data protection law in Germany to have a data protection officer. GDPR provides a provision to a certain when you need a data protection officer. And again, the Article 29 Working Party has guidance on when you have to appoint a data protection officer. And last but not least, in regards to relation with us as NGA HR, we are data processor of your data. All of this, what we just mentioned, we have or either to comply with directly, which is the breach notification to you, not to the data protection authority. You have to notify you. We can get fined if we don't comply with the GDPR. We have to have accountability and governance structure in place. We have, as a controller, comply with the individual rights and consent. We have to make sure that data transfers are in accordance with the GDPR. And all of that is dedicated or is included in Article 28 of the GDPR. If you haven't read it yet, we have read it and we have built our GDPR program around the obligations, especially when it comes to being a data processor. And with that, if I'm not mistaken, we're going over to a quick poll. Yep. How much do you think your personal data is worth to sources wanting to use it? Again, just another minute for you to have a look at that. And then I give over to my colleague, David Smighton.
Hello everyone, just going over an introduction again. My name's David Smighton, GDPR and Security Program Manager at NGA. Do we want to flick to the first slide, Caroline? Okay, so I'm going to just spend the next few minutes and few slides taking the information that Sasha's been through with you and trying to elicit what did that mean to us as an organisation? How did we review that regulation and build our GDPR program? So the first area to consider is we took a risk-based approach to GDPR compliance. If you look at the icons along the bottom, technology, security, vendor, compliance, and operational risk, they are generally, you could term those as causes of issues, the consequences of which could be strategic, reputational, financial, and legal compliance risks. Now, every organisation will have their own level of risk and risk appetite in each of these areas. We reviewed We reviewed these in line with the GDPR and all of the controls that we already have in place to build our program. Next slide, please. So another quick poll. What priority has your organisation put on GDPR compliance? Spend a few minutes thinking about that and completing that poll if you would. We'll of course share the results with you as part of the output. Okay, next slide please, Caroline, when you're ready. So, what are the main challenges? Again, this is based on our experience. I've been with NGA for since November 2016, and then what the challenges that we face in the intervening period. So, as mentioned a number of times by Sasha, we are both a data controller and a data processor. Obviously, as data processor from many of you for your information in terms of payroll, etc. Clearly, we're a data controller for information relating to our own staff and also marketing information. So we need to look at it from both points of view. Next challenge that we needed to consider is how we should implement the GDPR. Do we implement it regionally or globally? Are we just going to implement compliance with the GDPR in areas where we are processing and storing EU citizens' data, or globally? It will be no surprise to guess we chose globally. We're a global organisation. GDPR is really viewed as will be the gold standard in terms of data privacy. And just on practical terms, it just makes more sense to implement controls, both technological and organisational, consistently across the organisation. It just makes life a lot easier. Next challenge was to interpret some of the requirements of the GDPR. It is a large document. Safe to say that both Sasha and myself have read it at a number of occasions, and we go back to it every now and again. One of the requirements that is open to interpretation is the implement appropriate technical and organisational measures. So how do you decide what is appropriate? Well, again, this is individual for each organisation. It takes into consideration the current controls you have in place from an organisation and a technology perspective, and also your risk appetite and other, budget, your business you're in, etc. So again, you have to understand what do you view as appropriate technical organisational measures. Last and definitely not least, how do we make sure the GDPR remains a higher priority program? And this goes for any change or pan-organisation change program, which in effect the GDPR could be viewed as. Throughout a year or 18 months in any organisation, a vast amount of change will take place. Just the obvious one in our instance, we sold part of the organisation. I had a change of management, but it's very important to make sure that this remains high on the agenda throughout the period, and I'll come on and explain how we achieve that in the next few slides. Next slide, please. Okay, so this is a bit more information based on the slide that Sasha presented in terms of our experience. What does your GDPR program need to cover? So I'll start at the top, information management. So this area, clearly you need to conduct an information audit. It's up to you how you do that, either manually or having some sort of automated tool. I would always recommend with an automated tool, wherever possible. Clearly, manual surveys, etc. They're only as good as the information you get, and they will be out of date relatively quickly. We also implemented a records of processing activity, or ROPA, as we call it, and then make sure that within that record we're very clear what information do we store, why do we store it, and it's important to mention this is not the actual personal data itself, it's the metadata surrounding it. So take a CV, for example, you wouldn't put, you know, the actual names and addresses. You'd put, we have, you know, documents that contain names, addresses, work experience, etc. in CV format, and each of those needs to have an information owner, which leads you onto the information management process. Moving around to the right, staff awareness. Very important to build a culture of security and data privacy. There's a term often used is the human firewall. So, you know, your staff, your employees are your first line of defence. We already have an annual compliance training that is mandatory, but we've introduced general training and specific training for teams that are impacted within certain functions. So take our product development team, for example, they'll be the ones we take through our DPIA process, or data protection impact assessment process, which aligns with the privacy by design. Next one, access management. We already have access management, obviously. We took the opportunity to link that to our rights of processing activity, so our access management solution would link to the ROPA. Otherwise, you're implementing a lot of manual processes, which are clearly they're open to human error. Next one was security vendor assurance. Like any significantly sized organisation, we deal with a lot of vendors. So we've reviewed all our vendor processes. We have an annual compliance review with vendors. We reviewed all our vendor contracts and make sure we understand what data they've got and where it goes and data flows, etc. Security incident management. Obviously, we already have security incident management in place, but you need to ensure that you have an appropriate breach response process in place. Timing's perfect. We have a bank holiday weekend coming up in the UK, so this Friday and next Monday are both bank holidays. So you need to be very clear what happens, and God forbid, touch wood, it doesn't. If your organisation had an issue on Thursday at 4 o'clock before a long bank holiday weekend, have you got the processes in place and the people available? Have you got your responses? Have you got your legal team on call? If they need to review and contact your supervisory authority, have you got your communications? How do you manage that whole process? And make sure you practice it and you review on a regular basis. Moving around to bottom left, security governance, data protection impact assessment. So we've linked those to our records of processing activity. The way we've implemented our DPIAs, rather than just for major changes in processing personal data, any significant change within processing personal data, we've implemented a DPIA process which builds on our privacy impact assessment process that was already in place into our workflow that sits behind our software development lifecycle. Link that to the records of processing activity, so that if you've already completed a DPIA for a system and you're making some changes, you're not starting afresh. And again, automated workflows. We've registered with a number of supervisory authorities, but our primary supervisory authority is the Information Commissioner's Office in the UK. There'll be our single point of contact. Again, we already have risk management in place. We've reviewed all of our policies and updated where required. And we reviewed our HR contracts, and we didn't really need many updates there, to be honest. It's more of an opportunity to tidy things up. Security controls. So again, this will depend on the security controls you have in place. We viewed it as an opportunity to introduce more automation and integration with the various technical and organisational controls we have in place. Subject access requests. Clearly, as a data controller, we have to deal with subject access requests. So again, we've implemented workflow behind that, integration with our records of processing activity. And as you can see, this is the real foundation stone of our program. We've also in the process of making changes to some of our products, so that if our customers are required to search for data on their staff, there's a search facility in our new services and updates. Consent. We try not to rely on consent wherever possible. One area where we clearly have to is in the area of marketing. So we're updating all of our marketing solutions and services to make sure we record consent, and if anyone withdraws consent, that has a full process behind it, and we're updating all of our documentation. So that's a bit of a whistle-stop tour of how we've approached and creating and building our GDPR program. Next slide, please. Okay, another poll. Which of the following are proving to be barriers to your preparations for the GDPR? So again, we'll give you a couple of minutes to consider that. As I mentioned previously, we will share this the output with you at the end. Okay, whenever you're ready, Caroline. Okay, tips for running a GDPR program, again, based on our experience. Executive support and management is essential. We have regular updates with our CEO. Before he became CEO, he was on the steering group. And again, we need to make sure that it stays front and centre. Now to the bottom, dedicated program and project management resource. Yeah, I obviously would say this being a security program manager, but it was very clear from the outset that to really drive this pan-organisation change program, that you have someone who has experience of setting up and managing security programs, but more importantly, it's their full-time job. It would be impossible if anyone had to run this, especially within the NGA, as a BAU task alongside their day job. So you need an individual who needs to really drive it forward. We've had consistency of individuals as well, which has really helped. Moving back to the top, regular communications with key stakeholders. Clearly, as you'd expect, we have monthly, we've had for over a year now, monthly program reviews with our sponsors, who are ELT members, executive leadership team members. But I've had for well over a year now, I have regular meetings, so fortnightly meetings with key stakeholders within our business units, within HR, within legal, within finance, within marketing, etc. Just to make sure that if they have work to do, that they're kept honest and they hit their targets, but also to get the message out, but also to listen to concerns that people have within the business, to make sure we can address those, and we've covered everything. Next one down the bottom, enhance existing solutions if possible. I would say that this is probably a fairly standard tip for any technology program. If you have existing solutions in place, if you can enhance them and build on them, purchase new modules, develop new workflows, etc., it just makes uptake easier. If you do need to buy new modules, again, what we've tried to do is to stay as out of the box as possible. Bespoke always, to me, in my experience, relates to expensive and hard to maintain. We've automated our data discovery, and again aligned it with our records of processing activity, our data protection impact assessments, and our subject access requests, just so we're confident we don't have to have, say, an annual manual process. It just makes life a lot easier. I mentioned previously, we have controls in place already, so we've used the GDPR as an opportunity to increase our automation, consistency, make sure the processes are, as well as being written down, are implemented in a standard way across the organisation. Integration, you might have seen with a lot of the projects, we're trying to integrate as much as possible, and that goes within the business as well as the technology side. Security staff and data privacy staff awareness. So we have mandatory, we have had mandatory for a number of years, security and data privacy staff awareness training. We updated that last year to include reference to the GDPR. We're doing the same thing this year. We've purchased and implemented e-learning, etc. But really, we've taken the GDPR as an opportunity to really focus on security and data privacy as a whole, not just the GDPR. It's never a bad thing within an organisation. So take it and make things relevant to individuals in their home life. Where I've worked on this before, take a very simple thing. I'm sure you all run training around passwords and their standards around passwords, etc. Most people, have to have a certain combination of characters for their passwords, and they have to change every 30 days, etc. But if you start talking to people about passwords, what do they do in their home life? When was the last time you changed your Google or your Facebook password? 9 times out of 10 people have never changed their Google or Facebook password because they're not prompted to do it. So make things relevant to them, and it makes the message easier to land within the workplace. And last and not least, have a plan to move the GDPR program into BAU. I would very much hope that on the 26th of May that we raise a glass of champagne or something similar in celebration of finishing a key date within the program. The program will clearly carry on. And now, again, we're taking the opportunity to develop and enhance our overall general security and data privacy maturity. It's a bit of a catalyst. As I say, I've worked on these before. They don't happen overnight. You don't just finish a security program and walk away. You need to make sure that your subject access requests are still in place, your DPIAs are still being worked on, and then when people are filling in either the initial threshold questionnaire or the big questionnaire, it's being reviewed constantly and appropriate remediation is put in place. So you need to make sure, have this plan. Again, this goes for any major program. Don't just stop and think, right, on the 26th of May, that's it, all bets are off. You need to have a plan to move things ahead. I think that's it from me. Do we have another poll, Caroline? No. Over to you, Caroline.
Yep. No, we don't, David. No more polls, but we do have an opportunity for people to ask questions, and there have already been a number in the question box. So please feel free to put your questions in while I read out a couple of the questions we've already got. The first question is about 30 days. It says there's been a mention of 30 days, but the GDPR says 1 month, which isn't always 30 days. Can you clarify, please?
Yep, thank you. I think we're going to take that. So the GDPR effectively says a month, and obviously it's not always 30 days. Some months are longer, 31, or shorter, 28. So, but the general understanding is 30 days. These have to be 30 days, which starts counting. So there's a leeway. So if I ask you for information, if I exercise a data subject access request, but you don't know who I am, then the time doesn't start until you really effectively know who I am. So there's still the possibility that you can a little bit delay, unless the individual is very well versed about how exercising a subject access request. Then they will provide identification, they will tell you exactly what they want, etc. Obviously, this doesn't apply if it's your employee and you know exactly when your employee is, but a general understanding is 30 days upon request, and you effectively know that the individual who's asking for the information is the individual who can ask for information.
Okay. The next question is about deleting employee data. The question is, can you confirm that you don't delete employee data unless requested by the employee or the company you work for? The questioner says, I think our contract states that you retain data during the term of the contract.
So if that is a question for NGA HR as a service provider, the contract between any service provider and their data controllers or data control and data processors should be that information is not deleted upon unless the contract is terminated or unless the data controller tells the data processor to delete it. if the data processor deletes information that has not been requested by the data controller to be deleted, then they become a joint data controller with all the rights and obligations that they have. So if we delete, example, NJHR deletes data of one of our clients that we have not been requested to delete, even though we think, okay, that employee has left for, let's say, 10 years, there's no change to the data, technically there's no longer a right to process that data and take into consideration that storage information is processing data. If we would simply delete the data, then we would become a joint controller. Then employee comes back and said, I want access to my data. And we identify, okay, we should have not deleted the data because the time has not run out. The obligation and the possible fines would come to the data processor. So in regards to that, summing up, data processor should never delete data unless it's strictly allowed by the data controller.
Thank you, Sasha. The next question, is there any guidance on the retention period of terminated associates? How quick must people be forgotten?
Geez, all the questions are from me, I think.
I think they are, Sasha.
So data retention periods are a complex topic. Generally, so every country has their own data retention requirements, and they're not based on one single law. So I'm not aware of any country, and please, anyone on the call, correct me if I'm wrong, and I will be more than grateful if you can. I think there's no country in the world that says this is our data retention law, and this is all the types of data that you have to retain for X amount of time. So generally, for an existing employee, there's nothing you should delete even upon request, unless data is processed upon consent and they're not necessarily to provide or to comply with a legal provision. So if you do analytics on your employees, if you do something that you only do in your legitimate interest and you just don't have to comply with the law, then it could be arguable that you could receive a data a request for erasure, and you might comply with it. But as I said in the beginning, or as I said in my presentation, you always have to counterbalance your own right against the employee's right. So not necessarily because you don't comply with the law or that there's no legal obligation to process certain types of data, it is that you cannot process it. In regards to data retention, as I said, generally, if the employee is employed, you don't have to delete the data. Afterwards, it depends per country, but usually it is between, depending on the type of information, it is between 5 and 10 years that you have to store data.
Thank you. The next question is more about the, I think we can call it data supply chain. So are you responsible for ensuring that any partners, anyone you pass your data to, is also in line with GDPR?
I guess I'm going to take that on.
Yeah, and just to finish on that question, and if they are not compliant, who would pay the fine?
Okay, so if you go and take the GDPR, which is a very nice reading, so if you don't have the latest book that you wanted to read, take the GDPR and go ahead and read it. And if you want to need more information on data processor and data controller relationship, as I mentioned, Article 28 is the one. Now, what does it say in regards to obligations of the data processor and ensuring sub-processor compliance? You as a data controller, you have to make sure that the data processor complies with the GDPR. Does that mean that you have to go to them and check everything? You have to go one by one and saying, okay, show me what you're doing? No, you don't have to make sure. So you have to ensure that appropriate controls are in place you have to make sure that you can ascertain yourself that if you get questions by a data protection supervisory authority, that you comply and you can inform them, yes, my data processor complies in regards to my own standard and how I ascertain GDPR. Taking into consideration, all of this is based on interpretation. GDPR is not effective. No one knows how it's going to be applied by any data protection supervisory authority. Now, this is between data control, data processor. Now, data processors complying with Article 28, they do have to make sure that their subprocessor implements the relevant provisions of the GDPR if they process European data in or outside the EU. So, long answer to your questions. Yes, data processors, they have to make sure that subprocessors comply with the GDPR, and they are liable. They're liable if a subprocessor does not comply with the GDPR.
There is a section on this also in the GDPR guide for HR professionals, which we will send to you after the webinar, either this afternoon or tomorrow. So another question I fear for you, Sasha. What if 250 employees organised a request? Is it still 30 days for a response, each being individually tailored? And is there potential for malicious efforts to waste time?
That's obviously a good question. It would always depend because in the GDPR does not foresee that the motive for a request has to be disclosed. So if I ask you about my information, I don't have to tell you because I'm concerned about data protection. I'm concerned because I want to sue you. There's nothing that you can do towards me as an individual saying, okay, I won't disclose information to you until you tell me why you need it. That's not something that you can do. Is it suspicious that 250 employees come to you on the same day requesting the same sort of information? It is. Do you have to comply with it? Unfortunately, you do. The GDPR does not foresee, as current legislation, a disproportionate effort to reject or not to comply with the data subject action request. GDPR foresees a possibility to reject data subject action requests, sorry for that, if they are unfounded or excessive. But the burden to prove that is always on the data controller, so always on the organization who receives the request. So if you think that it is unfounded or excessive, you still have to prove as a data controller, as the one who owns the data, who is processing the data, that these requests are malicious, that they tend to whatever reason. Now, if you can't find a reason, if you can't find a reason, your legal department can find one, then you still have the opportunity to extend this month to an additional 2 months. So there's actually a free month period included in GDPR, which, however, you have to notify the data subject within 1 month of the recipient of the data subject access request. So within 1 month, you can either comply or tell the individual, sorry, I need 2 additional months because I have 249 additional requests who are asking me the same thing.
Thank you, Sasha. We've got one last question in the box. If anyone else has any questions, do still submit them. I think this one is possibly for David. What happens on May the 25th if you're not compliant?
That one's for Sasha.
Is it for Sasha?
I was afraid
Actually,
so.
I'm sorry, Sasha, I tried.
You tried, did your best. What happens if you're not compliant on May 25th, 2018? We'll see. May 25th, 2019 is a Friday. 2019-2018, sorry, it's a Friday. That means we have Saturday and Sunday. Do I personally, Sasha Snyder, think that on the following Monday, data protection authorities will rush into companies and saying, show me all your accountability regimes, show me how you have complied with data subject access requests, show me this, show me that? No, I don't think so. Did certain data protection authorities, the French CNIL included, say that certain fines based on certain rights will not be enforced 100% after May 25th? Yes. Does that mean you don't have to comply with the GDPR as of May 25th, 2018? No. GDPR has had implementation of 2 years, an implementation time of 2 years for companies. So Data Protection Authority will come to you and saying you have had 2 years and you're not compliant as of this day. Can you get fined as of May 25th, 2018? Yes. Do I expect, Sasha Schneider, that this will happen? No, I don't expect it. However, don't be surprised and don't come back to me if you do get fined for anything that that you might have been doing.
The thought process is, if you can demonstrate that you are a long way into a compliance program and you're 95% of the way, there will be leniency showed. But as we say, we are in this with you.